Aloha, it's Professor Porter. We're talking about the Federal Rules of Evidence, in particular hearsay, and we're into not only some of the definitional stuff in 801, but now we're in responses for the proponent and definitional not hearsay, exemptions to the hearsay rule that are available to the proponent when responding to a hearsay objection. And you see them highlighted in this middle panel here: prior inconsistent statements, prior consistent statements, pretrial IDs, and statements against party opponents or statements attributed to party opponents. And really, most of them are handled in other videos. Today we're going to talk about pretrial identifications, and really what we're talking about is out of court identifications, because if you think about in court identifications, when you see in the TV and the movies where there's a criminal trial and then at some point when there's a witness or a victim on the stand, you say, do you see that person? Do you see the person you're describing as the defendant in the courtroom today? I do. Would you point at that person and describe an article of their clothing or what they're wearing? They do so. Maybe the prosecutor at that point says, will the record reflect that the witness has identified the defendant that's on trial? And you have to prove identity as a prosecutor, so those in-court identifications. But if you think about that, it doesn't suffer from any hearsay problems because we have a witness on the stand testifying contemporaneously, and they are saying, testifying in court or pointing out in court, which is a verbal assertion and also a statement, but it's not an out of court statement offered for the truth of the matter asserted, so it doesn't suffer from any hearsay problems. What we're talking about today are pretrial identifications, whether it's a live lineup type of identification with one-way glass where you go, the person goes to the police station, the victim or witness goes to the police station, looks at an array of people in a lineup and says that person number 4 is the one that did it. Well, that's out of court. It's a statement, and when introduced at trial, it's going to be offered for the truth of the matter asserted, even if they didn't say anything. That's a verbal conduct with plus intention of the declarant, so it's going to be an absolute statement that's offered for the truth. So we need to overcome the hearsay objection from our opponent, we need to point to, as the proponent, a not hearsay defined under 801D, and that's 801D1C for pretrial IDs. Here are the three rules under 801D1: prior inconsistent statements, and that's the what I call the fancy kind. That's the kind where we can introduce it for the truth, for substantive evidence. It's not just used for impeachment. It's not just used to show that someone said different things on different days. And then prior consistent statements to rebut a recent charge of fabrication. And then this, I think, is the easiest one. Prior identification is the easiest one to understand, and the foundational requirements are really only these three elements. So here it is. The yellow box above is consistent for all of 801D1, the not hearsay defined. That is, our declarant, our witness, is on the stand right now. So the person who's conducting, the person who did the pretrial identification is on the stand testifying. Declarant is the witness. Think about it. With most of hearsay and most of the problems with hearsay, the declarant we never get to meet, we never get to cross-examine, the jury never gets to evaluate that person's credibility, and the witness is someone else. The witness is dragging in a quote bubble that belongs to someone else, the declarant. Here, the declarant is the witness. The person who had the earlier statement outside of court is the witness. So I am Porter. I'm a witness to a crime. Sometime months ago, closer to the date of the crime, I went to a lineup, or I went to a photo array, and I was working with law enforcement, and I said, that's it. Number 6 is the one who did it in this photo array of eight people. Or I went to a live lineup where people lined up, like you see in TV and the movies, and I said, that's him. Number 4 is the one who did it. Number 4 is the person who committed the crime in this case that I have personal knowledge of, that I was witness to. So I, fast forward, that person who made that out of court statement, offered for the truth of the matter asserted, the declarant there, I'm also the witness. I'm testifying. So of course at trial, like we talked about, I could do my in-court identification. I could say, that's the person who did it. A contemporaneous conversation where I can say, based on my personal knowledge, based on what I witnessed, that's the person who did it. No problem there, no hearsay implied there. If we say, 3 months ago when you were looking at a photo array, or 3 months ago when you were looking at the lineup through the one-way glass, let's put on your pretrial identification at that time. Now I have a hearsay problem because it is an out-of-court statement, truth of the matter asserted. If my opponent objects and throws the hearsay flag in the middle of the ring there, I know that they're right. It is an out-of-court statement, and I absolutely am offering it for that purpose of to prove the truth in quote that that's the dude that did it. So we need our own not hearsay defined. We need our own hearsay exemption under 801 D1 capital A, and that is the first two are easy. Declarant is the person on the stand. I, Porter, am the witness on the stand. So the same person that made the statement out of court for the identification is the same person that's on the stand. And of course, if I'm on the stand, I have to be subject to cross-examination. I can't sort of bail after getting in my identification. I have to be subject to cross. It doesn't mean that cross-examination has to take place, or it doesn't even mean that cross-examination has to be particularly meaningful, just the opportunity subject to cross. And then the easiest requirement, the pretrial statement, is an out-of-court identification. So as long as you have those three things, I'm here at trial now, I'm subject to cross, and I'm testifying about a pretrial identification outside of court, it's going to be admissible. It's going to be not hearsay defined as the 801 D1C. So it would go like this. The proponent would be asking questions of me, the witness and declarant for the pretrial identification. I would say, did you have the opportunity to look at a photo array at some time? Objection, hearsay. Proponent makes their way over to sidebar. Your Honor, the declarant is on the stand testifying at this trial. The declarant is subject to cross-examination. And lastly, this is an out-of-court identification. We meet the foundational requirement of not hearsay defined, of this hearsay exemption under 801 D1A, D1C. So therefore, allow this into evidence, and that objection would be overruled, and the evidence would be allowed, and the witness, the victim, Porter, would be allowed to testify as to the pretrial identification. That's how it happens in court.